Yeah, so we have 5 questions today. So the first one is, how do I search for information on a house or a property? And I get this question quite a bit. So there are a few options. So the first one would be the county clerk or the recorder's office. They all have their websites, so you can check that information online and it's free. You can check the deeds. Also with the recorder's office, you can check who the former owner was, and you can actually look pretty far into the chain of title. I get asked a lot, once you transfer your property to a land trust, that you're still listed in the chain of title. So that's how the person looking for the previous owner, they would check with the recorder's office. That's where they would see that information. From a legal standpoint, that's not a concern because you're just the former owner, even though you're still in the chain of title. Another option would be to check the local assessor's office. So it's the tax assessor's official website, where you can check who the owner is and also see the property tax records. Another option would be to work with a real estate agent, but they would most likely check the information from those sources that I just mentioned. What else? I know some people like to search for the information on websites such as white pages. I usually do not recommend that because those are not really reliable as far as searching for who the actual owner is. As an example, I tried searching for my father's house. He lives in Pennsylvania, and even my grandparents showed up somehow associated with the property, and they don't even live there or not even in the state. So it's just as an example. I don't know, Jason, do you have any other thoughts on this?
Yeah, I think you covered it pretty well, Olia. I guess the only other like little additions that I would add on are in certain parts of the country, specifically the East Coast. I'm thinking specifically about certain areas of Connecticut. It's actually going to be found at the city recorder, not the county recorder, or it could be a township recorder as well. Another thing, if you wanted to get really detailed on this, is certain county recorders are more modernized than others, and so depending on where you're at in the country, some of the records might be digitalized, others may not. So I've worked with certain county recorders where records were digitalized up until from like 1980 to 2023. And then you'd have to actually go to the office to look at anything beyond that. So it's not that the records don't exist, but you just would have to do more digging. But this is obviously really detailed information.
Yeah, you can always also work with the title company, of course, and this step is always part of the home buying process, and they will be able to provide search, the title search, but that is not free as opposed to the other options. And usually a title report can range anywhere from $200 to $400, depending on the company and the state also.
All right, so this next question is more related to the real property transaction itself, and probably it's attorney slash like realtor land, I guess, more realtor land maybe than attorney in some states. So this is related to inspections for houses. And basically the scenario that was proposed was, if you found various minor issues with the home, if the realtor told you to just let them go, or whether you should ask to have them fixed, will it make the seller mad? What should you do? What's the advice? And my answer to this, I was a realtor for a short while, a few years ago, and I just said that it's really market dependent and based on your motivation to buy the house. If it's just a rental house and you're not in love with it, a lot of times I actually looked at these as if they're not major fixes, actually as a benefit, and I would just ask for everything to be fixed or ask for money back in order to negotiate a better price. But if you're obviously very attached to the house, this could be cause to create some ruffles between you and the seller, and it's possible that they could try to back out on some other pretense and resell the house if it's a really hot market. But generally, I'd say you could ask for anything that shows up on the repair list to be fixed or credited. The seller can feel free to disagree or be mad with it if they want. You could also limit the request if it was really something that you were worried about to the most important issues. And then, obviously the advice on this is like I said, fact dependent and varies based on the circumstances, the market that you're in. Olia, did you have anything to add to it?
Yeah, I know that there are some repairs that are mandatory for the seller to fix, but those usually include issues that are related to safety. But so third question, I just put an offer on a house and the neighbors came out and they were horrible. The seller accepted the offer, but now I'm not sure how to proceed. What should I do? Should I back out? So the main question here is, can a home buyer back out of an offer that they already accepted? And the short answer is yes. When you sign a purchase agreement for real estate, you are legally bound by the contract terms, and you normally give the seller the upfront deposit, which is called the earnest money, which then sits in escrow account and will be used to pay a portion of the closing costs at settlement. If you back out of the contract, the seller can keep the deposit if the buyer breaks the contract without a contingency or a valid reason to do so. So it's very important to review the contract and make sure you have the contingencies built in there that are protecting you. So a few contingencies that are common would be property passing the inspection, which we discussed in the previous question. Buyer being approved for financing, it's very important as well. Property appraising at an acceptable value, and being able to sell the existing home for the buyer. Again, very important to keep in mind. I know, Jason, you mentioned something about the appraisal gap contingency that is quite relevant now. I don't know if you could maybe speak to that a little bit.
Yeah, it's probably changed even in the last couple of months, but basically there was a contingency that would be put in where house prices were rising so quickly that the appraisal and the actual purchase price were different. The bank was being more conservative. The price that they were paying was exorbitant. And so without the contingency in place, it was just kind of, you were put in an awkward position where you'd have to come up with that extra money to cover it if you didn't have that accounted for in the loan. A lot of people were actually waiving those to make their offers more palatable or more desirable. It's obviously dangerous to do that unless you have the money, but that was another contingency that Olia and I had discussed. So, and a way that you could get out if you happen to have that.
Okay. One thing I did want to add is that it's also very important to pay attention to the deadlines that are attached to each of the contingencies. So, for example, you may have a contingency where you're required to complete a home inspection and ask for any repairs or potentially credits within 14 days. So you need to pay attention to that, or a financing contingency might need to be met within 30 days to get final loan approval. So very important. So the bottom line is, yes, you can back out, but there may be some monetary consequences. So this is question number 4. So I'm looking to create a Series LLC in Texas, which is, as we all know, a series state for rentals located in North Carolina, which is a non-series state, and register in North Carolina as a foreign entity. Since North Carolina does not recognize Series LLC, I'm concerned that it will not recognize the internal liability shield for child series granted in Texas. Yes, so the main thing I want to say here is that not all states allow the in-state formation of the Series LLC. That's different from not all states recognizing the Series LLC, because all states will recognize the Series LLC that is validly formed in a state that allows for a formation of this type of entity. As an example, the Series LLC is and will be recognized by a North Carolina court, just based on the full faith and credit clause of the Constitution. And this also means that any child series would be treated as isolated if it was run as a separate business. One thing that we always mention is that the Series LLC are not to be used for any active operations. We strongly discourage that you move any active business under a separate child series. That's why we always insist that you have a separate LLC that is used as an operating company. So you separate your assets from your operations. So this way, the Series LLC is completely isolated. It should not be signing any contracts. It should not be collecting any rental income. It should not be paying for expenses directly. That should all go through the operating company.
Sure. The fifth question is pretty broad, and we see this a lot. So it's, in what state should I file my LLC? So obviously that is super context specific. I think more or less the question that Olia and I wanted to address is, you have somebody who asked the question, let's just say they're in New Jersey and they have a property in Ohio, and should I have a Wyoming LLC because it has really good asset protection virtues? Should I have a New Jersey LLC? Should I have an Ohio LLC? Well, if the LLC is owning the property directly, it should be an Ohio LLC, or it should be a New Jersey LLC that's registered in Ohio, or I guess you could theoretically have a Wyoming LLC that's registered in Ohio. So you're going to want it to be from the state that it owns property, if it owns it directly, or registered to do business in the state where it owns property. And that would also be true of any operating company that's considered doing business in that state. So the risk, if you look at case law, not so much on the there's a risk of fines. That's not in the case law side. If for whatever reason you get caught doing business and you're not registered to do business. Now, on the case law side, if you look at it, there have been LLCs that have been invalidated because nobody's going to stop you from recording a deed, from John Smith to an LLC from Wyoming and Ohio. The recorder isn't looking for that type of information. They don't care. So on the face, it seems like it's not a problem. If that Wyoming LLC gets sued by a tenant or whatever in that house in Ohio, there's a chance that the Ohio court is just going to disregard that Wyoming LLC because it's not registered to do business there. And that's a huge risk that you're taking by doing that. So like I said, the ideal solution is, if you want to use that Wyoming LLC, register it to do business in Ohio. So I think that's the scenario that we wanted to boil it down to, because that question is obviously too broad to talk about every single aspect and context. Olia, anything?
Just one thing I wanted to add, that if you are setting up the LLC to close on a property, a lot of the time, of course, you will need to register it in the state where the property is located for the closing purposes. But aside from that, yeah, I think we covered it.
Cool.